Okay, so we have, we're in workshop, so I'm not gonna call any meeting to order, but, and we're going to be discussing, the update to the shoreline ordinance. The only, I guess, announcement I would make, if you haven't heard, the Board of Selectmen did pick, Marilyn Hunter, to replace Andy, so she was on the plane this morning when I went to Florida, but she'll be set with our next meeting. And she has been sworn in.
Did I miss something? Did Andy term out or did he resign?
He resigned and asked he wants to go on the historic committee.
He's already on, he's been on the historic committee, so he's staying on that.
Anyway, so, what of any other announcements? I think, you want to kick off, or who wants to start this?
You guys are good to go.
Go right ahead.
And Matt, you would please let everybody know who you are.
Oh, sure. Well, I'll use the podium in case you need this for sound for anybody watching online. Yes, good evening. My name is Mike Morris from Archipelago in Portland. Senior environmental consultant at Archipelago. Joined also by Sophia King, who's one of our project managers at Archipelago as well. We appreciate the opportunity to be here this evening to discuss shoreline zoning, but more importantly, the proposed draft shoreline zoning amendments that we were asked to prepare for the town, for the town's consideration. So I wanted to just spend a few minutes to 2 hours, somewhere in that range, going over a few basic notes. Mostly, my understanding is I think the planning board wants to understand kind of the why we're doing this, or why this is important, and all the rest that runs with that. So I'll just stop myself and just say, at any point in time, if any of you have any questions about something I've just said, or something I didn't say that maybe you wished I had elaborated on, please feel free to ask. This workshop is hopefully going to be as beneficial to you guys as possible. So if you have questions, go right ahead and ask, and there'll certainly be time at the end to ask questions as well.
So I do have just one brief question. I was just about it.
Sure, that was quick.
It's not giving them the license. It's just more on the process, right? I know you're going to be giving this to us in workshop. Are we going to have him back for the public hearing?
I don't know if we planned on that, but if you guys feel really.
We haven't typically.
Yeah.
I just.
I think if we hadn't discussed it, I think we felt that it was necessary, he would be able to, but.
Because essentially our process is to go through, do workshops, and then essentially decide whether or not we think it can go to public hearing, then it goes to a public hearing.
Right.
And after that, then we take a vote from the planning board to say whether we recommend it ought to pass or not.
Sure.
And then that goes to the select board, who also does it, to determine whether it goes onto the warrant and to go to town meeting. So, okay.
If it would be helpful to the town, to the board, I'd be happy to participate in the public hearing. Be happy to do that.
Thank you.
But by the end of this evening, you're going to all be experts in this. So
That's exactly why I said that.
all right, so we'll jump right into it. So shoreline zoning is a result of a state law, the Mandatory Shoreline Zoning Act, that was enacted by the legislature in the early 70s. And the law required another state agency eventually that became DEP to develop these certain minimum shoreline zoning guidelines. So it's the model ordinance that a town would utilize in adopting and amending their local ordinances. These are the Chapter 1000 guidelines for municipal shoreline zoning ordinances. And the law says municipal ordinances need to be consistent with the minimum requirements of the law and the minimum requirements of these Chapter 1000 guidelines. And these, by the way, the law is very rarely, but occasionally amended from time to time by the legislature, but more frequently, and it's not even that frequent, the Chapter 1000 guidelines are amended. Sometimes they're minor amendments, sometimes they're fairly comprehensive. So the task that I was requested to assist the town with was to identify inconsistencies in the town's current ordinance, which, if I understand, the shoreland zoning component was largely or primarily adopted in 2008, perhaps. Does that sound right, Tom?
Sounds right.
And to identify these inconsistencies and then to draft ordinance amendments for the town that would make the ordinance consistent with the Chapter 1000 guidelines and of course the act as well. So we did that and provided those different documents, so the different sections of the ordinance to the town. And that included the primary shoreline zoning provisions. It included a few changes in the administration section. It included some definitional changes, just to add the consistency, and I may be forgetting some other changes, but I think that was primarily it. The reason there are changes is because the Chapter 1000 guidelines were amended by the DP or by the state back in 2015, January 26th, 2015. And that they were also amended with a minor amendment in 2012. But the 2015 changes were far more comprehensive and had a lot, much greater consequences, I'll say, in how shoreline zoning is administered. And I'll just talk about a few of those things just to give you a taste of that. But before I jump into that, part of why we're here talking about this tonight, part of why the town asked us to help with the draft amendments is because the state says, well, if your ordinance is inconsistent with the state minimum standards, then the town under the law has the state under the law has the ability to adopt what they call a state imposed ordinance on the town or for the town. So what that would look like is they'll simply take the Chapter 1000 guidelines. They won't edit it for things that are, with edits that would be relevant to the town of Topsham. They're just going to give you the Chapter 1000 shoreline zoning guidelines, stamp the name Town of Topsham on the top of that and say, here, now go administer and enforce this. But you also the state cannot repeal your existing shoreline zoning ordinance. So you're also on the hook for administering and enforcing that as well. So when you have conflicting ordinances, now what do? It's going to always be the more restrictive provision controls. It's going to cause a guy like Tom to pull his hair out, and probably you guys, we're all going to look similar within another year. So, because you're trying to apply all the different standards, your current ordinance plus some state imposed ordinance. As far as I know, the state is not threatening that yet for towns that have inconsistent ordinances, but they do threaten that.
So let me, I guess at the high level, basically what this is doing is realigning us, so to speak, or at least taking out some of the discrepancies we have, so that it aligns with the state ordinance, right?
Correct.
And are we doing anything that's making this shoreline more stringent than the state requirements?
That's a very good question. And I would say, I'll answer it this way. When we were tasked to provide the draft ordinance amendments, it was suggested and recommended, and we agreed that we should just take the Chapter 1000 guidelines and pare that down to what's applicable to the town of Topsham, so that we know exactly, that your ordinance would then be consistent.
So we don't expect it to have something more stringent.
So I did not spend hours and hours and hours pawing through your existing ordinance. I've spent probably more time than you would want me to spend pawing through that. But all that to say, the purpose behind the DP amending the guidelines, the Chapter 1000 guidelines, 2015, was not to make them more restrictive, but to add lots of clarification on things. And I'm going to touch on a few of those things. And to make some pretty substantial changes to sections like the non-conforming structure expansion section. You know, how when your house is too close to the water, you know, you're limited to expansion, you're limited on this, that, and the other thing. Not to make it more restrictive, but the old way of doing it that's currently in your ordinance was so difficult for a lot of towns to administer. And I'm looking at Tom. I mean, Tom knows how to do it because he's an expert in this for having done it for so many years. But a lot of municipalities have newer CEOs, and it's difficult to comprehend how is a code enforcement officer going to calculate volume of a structure. I'll get into some of these details. So to answer your question, the state's intent was to not make this any more restrictive, but to make it clearer and consistent conceptually with the existing standards.
So I wasn't, and I think that's fine, and I'm not trying to. So essentially, we're trying to align with this, this is aligning us with the state more correctly.
Yes.
Than we've been. There wasn't an effort to make anything more restrictive, which the town could do, right?
Correct.
And I guess the only other question I have, and maybe I have to look at Tom, and in some of our former, I guess, approvals or whatever, do we have exposure?
No.
Okay, good. That's all I need to know. So anyway, go ahead, sir.
All right. So I'll just walk through some of these, and I mentioned the non-conforming structures, just to give you a taste of the more significant or substantial changes. I mentioned non-conforming structure expansion. So today, not to get buried in the weeds, but right now your ordinance says expansions of non-conforming structures that are too close to the water are controlled by two different metrics: floor area and volume. I mentioned this a few minutes ago. This volume is difficult to calculate unless you have a CAD program in front of you and you can calculate all the different angles and this, that, and the other thing. Face the reality, we don't have a lot of just boxes, you know, with a gable roof these days. We do have those, but we have a lot of complicated roof designs and this sort of thing. So how is Tom ever going to figure out, or how is the planning board ever going to figure out, does this expansion comply with the floor area and volume expansion? So those metrics changed with the 2015 Chapter 1000 guidelines to two different metrics: footprint and height. Footprint is just what's on the ground, you know, the amount of the structure that's on the ground. It doesn't have to account for multiple floors. Do you have a second floor? Well, what about the attic space? You don't have to account for volume. It's just footprint and then overall height. And the further back from the shoreline that a structure is, the bigger and the taller the structure can be. You asked whether, you know, any of this is going to be more restrictive, and I'll also answer that again by saying, with this particular change, in some cases it is more restrictive for a given landowner, depending on the situation. But I would say more likely than not, most of the time, it's actually a little less restrictive, and a landowner can do a little bit more. You're not giving away the farm. If you want to be protective of the shoreline, it's not like you're giving away the farm. So anyway, that's one of the changes. What's important about this is if the town does not make the changes, does not adopt these changes specifically to some of these sections, like non-conformance, the state will say, they have said, for those towns that have not made the changes, you have to apply, because this is founded in state law, and the state law says towns shall administer these footprint and height standards. The town is now required, technically, whether the town knows it or not, was required to apply the current floor area volume that's in your ordinance and also the footprint and height metrics that are in state law. And that just it's not impossible. I've worked with a lot of clients working through that with potential designs, and I've worked with a lot of towns trying to help them get through that sort of review. But it just adds another 10 layers of complication. So it's just, and how does your code enforcement officer enforce that? That is extremely, extremely difficult. So that's one of the problems with this deficiency or inconsistency in your ordinance. The next that I'll jump onto, and we can talk about non-conforming structures. I can probably go on till about midnight if you want to talk about those. But just to give you an overview, one of the other changes that was in 2012 was the state said the shoreland zoning towns no longer need to administer or require resource protection districts around waterfowl and wading bird habitats, tidal waterfowl or inland waterfowl and wading bird habitats. And it's not to say the state's giving up on regulating those and they're not important. Just quickly, the reason for that is, excuse me, please, is the Department of Inland Fisheries and Wildlife wants to see these waterfowl and wading bird habitats protected and managed and that sort of thing, so that the waterfowl and wading birds will still use them and flourish, which is great. Except they went to DEP many years ago and said, we want to have all these areas protected with a resource protection district by municipalities. Which sounds great, and they created some maps. I'm thinking back in 1989, I think it was, created a whole host of maps all over the organized towns in the state and said all these areas have to be resource protection. And so towns adopted zoning maps, and the Town of Topsham zoning map currently has resource protection for some of these waterfowl and wading bird habitat areas. And then later Fish and Wildlife said, gee, you know what? We want to be able to tell somebody on a case-by-case basis that you can go ahead and develop here because it's not going to impact the waterfowl and wading bird habitat because it's way over here, it's whatever. For whatever reason, on a case-by-case basis, they wanted that flexibility. And so they came to DEP and said, we don't need to have a 250-foot resource protection district where you essentially are saying no to a landowner. No, you cannot develop your land within 250 feet of these areas. Instead, it gives Fish and Wildlife the opportunity to weigh in on a case-by-case basis. Case-by-case basis, not under the town's ordinance, but under a different state law that we won't get into all that much tonight, or at all. The Natural Resources Protection Act also regulates these same habitats, these same wetlands, these same streams, these same areas. But under that regulation, it's not a 250 feet, you can't do anything. It's, if you're within 250 feet, you can apply for a permit, and then Fish and Wildlife will tell them yes or no, based on the site conditions. So it actually makes far more sense and gives folks a lot more flexibility. So this isn't, it would roll it back, if so to speak, at the local level, and that you would no longer regulate with a resource protection district these types of habitats. But it's not to say they're no longer protected. And I just want to make that perfectly clear. So they are still protected by DEP and Fish and Wildlife's review. All right, moving ahead, the lot coverage standard has been clarified. I won't belabor that. That's the amount of the lot that can be covered by structures, driveways, parking areas, and other non-vegetated surfaces. There's some clarifications there to help with the town's administration. No more restrictive, it clarifies. Timber harvesting, there are some changes, but those timber harvesting in the shoreland zone, the authority over that has already been repealed by the Town of Topsham back, that might have been 2008 or 13. Okay, so that's gone already. And then there are a number of changes within the other vegetation removal standards within the shoreland zone. So If it's not a timber harvest, you're just clearing a few trees around your house, or you want to clear that patch down by the shoreline, there's this other section of the ordinance for vegetation removal within the shoreline zone. And there are a number of changes there that I would say, again, don't make it any more restrictive for the most part. There are clarifications that will help a landowner to better understand how to apply the rules, and it helps the town to better understand how to apply the rules.
So we're not asking for any kind of tree size surveys or anything like that.
We still have the planning board probably would not. The code enforcement officer might. There's still the somewhat clunky plot and point system where you have to measure diameters of trees. You have to have so many points of trees within a 25 by 50 foot plot area. You know, just as an example, you still have that, but it's clarified. That's not necessarily simpler, but it clarifies what the intent is and what.
So would that be within the building envelope, basically, or I'll just say the whole lot?
Yeah, great question. So that applies specifically to the shoreland zone buffer. So if we're within the shoreland zone of a stream, that's a 75-foot stream protection district, not 100. 75-foot stream protection district. If it's up against the river, that's a 250-foot shoreland zone. Again, you only have a 75-foot buffer where these more complicated vegetation removal standards apply. There's still standards beyond 75 feet out to 250, but they're less restrictive. They're, far more permissive and far simpler to apply. So vegetation removal standards. With that, there's the addition of several new standards associated with vegetation removal. Namely, there's a new section on hazard tree, storm damaged tree, and dead tree removal. That's something that's been regulated for eons, but just not very well. What is a hazard tree? There wasn't even a definition for what a hazard tree was in the Chapter 1000 guidelines. There is now, and there's a section to describe what these are and when you can remove them. There is a section on exemptions, specifically exemptions for removal of vegetation in the shoreline zone for like brownfield and VRAP sites. Where you have old contamination from the mill building or whatever, and vegetation has to be removed in order to mitigate that or to do something to protect that and keep it encapsulated or something. There's an exemption for emergency response. Somebody's heating oil tank spills and ends up heading down towards the water. Well, there never was an exemption for that. And so could they remove the vegetation? Some code enforcement officers are very reasonable and would say, yes, you got to clean up that oil. We'd rather get the oil, keep the oil out of the water than save 4 trees. Other IEOs would use the language very strictly and say, no, you have to work around those trees. And
that's why we're fortunate to have Tom.
Right. Yeah, amen to that. So there are some other exemptions built in, removal of non-native invasive plant species. Why can't you do that if you have a Japanese knotweed or bamboo infestation on your shoreline and it's really, frankly, quite ugly and it's a monoculture? Can you remove that? Well, yes, you can. There are standards that run with that. But anyway, that's another set of standards that was added. Shifting gears, go right ahead.
Over there. So basically, the applicant would be telling, here's what we're doing in regards to that. But we don't enforce. You would still be making sure they comply with what they said.
Yep. Yeah, many of these changes are going to relate more to that guy than they will to you.
That's what I'm thinking.
But since there's a process,
No, that's fine.
you guys have to have buy-in or not to move it forward. So shifting gears a little bit from vegetation, you're probably thankful for that. There's a state law requirement that excavation contractors working in the shoreline zone must be certified by the DEP in erosion and sedimentation control best management practices. So that means that the guy that's excavating for a living in the shoreline zone has to be certified to ensure And they go through a training class at DEP. It's a little painful, I'm sure, to those having to go through it, but I hear it's okay. I haven't attended it.
So is that new?
That's a new state law as of probably like 2013,
Okay, so it's not a
20.
new requirement, Ron, it's not,
I've gone through it.
okay,
Yeah.
In fact, you gotta do so much of that every year.
okay.
Yeah, so it's a burden for contractors.
Yeah.
I don't need your acknowledgement. I would know that.
No, I understand, but to the
But-
extent it's not new, then
Right, it's not new. It's like 2013 or 14 maybe.
We're already doing that.
Yeah,
Yeah.
right. And so well, that's a provision that's added because you don't have that in your ordinance. So how can you enforce that? Well, it's in the state law and it clarifies that this is added. And then I mentioned there are a number of definitions. Hazard trees, storm damaged trees, we define tree, we define sapling, seedling, all these different definitions.
we haven't changed the definitions of streams.
And yes, did you have a chance to read the
I read
draft?
through it, but I'm also a realtor,
Oh, okay. Oh, excellent.
and so's Tim, so. Tim,
So
speak up if you want.
Streams,
Okay.
the stream definition was amended. Now, if you're thinking about the pre-2015 Chapter 1000 guideline definition to the post, to the current post 2015, it didn't change a whole lot. And I'll tell you what that change is, and then we'll talk more specifically about the Town of Topsham. The change within Chapter 1000, just the Chapter 1000 definition of a stream formerly used the blue lines below the confluence of two perennial streams as depicted on a USGS topo map. Remember those big old USGS topo maps? That's what we're referring to back when we had paper and we didn't do things digitally. There's some better data. I would say better, or there's newer data that is utilized now in the definition, and it references these same lines, these same streams as identified in the National Hydrography Data Set, or NHD. And that's just a digital data layer that Sky can pull up, and Tom can pull up, and we can pull up. You can pull up if you get into a GIS system or something like that, and you can see where these areas are. The difference is going to be bigger for the Town of Topsham, I think. Without scrutinizing your map, what do you have currently for streams, and what are you going to have? What are you going to have for streams? That's something your mapper would help you with. But the definition will change pretty significantly from what it is currently. So currently, I mentioned earlier this other DEP law, the Natural Resources Protection Act, or NRPA. The current Topsham definition of a stream is very similar, not 100%, but quite similar to the DEP's Natural Resources Protection Act definition of a stream. The problem with that is that under the NRPA, DEP doesn't have to map any streams. There is no requirement to map or zone streams. Shoreland zoning is like a zoning district, of course. Towns have, municipalities have zoning districts. And so zoning districts have to be depicted on your on your zoning map, or in this case, your shoreland zoning map. And the definition, so DEP has this similar definition, and they just say, here's what we regulate. And by golly, if you're out there developing a piece of land or doing something on your land near one of these things that would qualify as a river, stream, or brook under their definitions, then you darn well had better get a permit from DEP to be able to do that activity. It's different with a zoning ordinance or shoreland zoning in that you're supposed to show these streams as a stream protection district on your zoning map. And your map does have some stream protection districts. But I can tell you, without reviewing your map at all thoroughly, I can guarantee you 100% that your map does not include all of these little channels that your definition would consider to be a stream. So what do you do? Do you ask your CEO to go out and conduct stream determinations? Well, Tom's a jack of all trades and very knowledgeable, and he probably has the skill set to do that. He may not have the time to do that as a code enforcement officer because that takes time. You got to dig around in the stream bed and look for insects, aquatic insects that have burrowed down into the bottom of the stream bed if the stream bed's dry. You gotta look at these different characteristics to determine whether it's a stream. And suppose he finds one of these that isn't depicted on your zoning map. Well, now what do you do? Because if it's a stream protection district, it needs to be depicted on your shoreline zoning map or your zoning map as such. Well, what do you do if it's not? I don't think you're allowed to regulate it. So it's really a difficult, very, very difficult definition for the town of Topsham to have.
So at least for where we are at though, we're not proposing something that we're gonna have a bunch of property owners up in arms about.
I don't know. I can't say that because I don't know what you have for streams compared to what you would have for streams under this national hydrography data set layer. You may have some folks upset. My response to them, if you invite me back to the public hearing and people are getting up there with pitchforks and torches and ready to burn the place, hey, look, whether the town regulates these or not, they're already regulated by the DEP under the Natural Resources Protection Act and the U.S. Army Corps of Engineers. So it's not as though they're not regulated. They are regulated, whether they're shown on a map or not.
Give like an example of when you run into a problem with something like that.
Yeah, I mean, the typical problem is you run into, we're out in the woods, landowner wants to do a project and they say, well, I'd like to put a house here. And we have this low area, this drainage area is usually how a landowner would describe it. Then you go out and you see this carved out channel and it might be this wide. And it might be from the top of the embankments of this eroded out channel, it might be this deep. That would never get picked up by this national hydrography data set as a regulated stream.
But it could be considered a stream.
But your ordinance today would likely, depending on the situation, would very likely regulate that as a stream and should be depicted on your map as a stream protection district. So what do you do in that situation? That's where we run into that.
Oh, go ahead. Right. Where we would see that though, to your question was when someone's here with a subdivision, and they have something that is encroaching where they're trying to get so many lots and so many homes and their building envelopes and everything else. If they're trying to work around that, then like you said, they'll call it a drainage ditch. I think the most famous drainage ditch in Topsham is down by the boat and mill. Other people call it a stream, some people call it a drainage ditch. And I don't think that debate's ever been won, right? But that being said, that's where you would see it when it comes to us.
Don,
Go ahead. I'm sorry.
well, just to follow up on that, so when it comes to you, it's coming through somebody who's done
Right.
hydrology.
The engineering staff.
So the NERPA and Army Corps, they're gonna apply whether they call it a drainage ditch or not.
Right.
So at this level,
We won't be
It's gonna-
deciding that.
it's gonna be
We'll get
regulated.
the experts on.
It's just like a vermin.
that,
Right.
yeah.
Right. Do you have a question,
Sorry,
sir?
Larry, go ahead.
Yeah, so what you're saying is that what is in front of us tonight changes what we have right now with regard to streams? As far as less restricted or more restricted?
Well, it's a great question. And my answer to that is on paper, I would say it's probably less restrictive. In practice, in real life, it's either, it could be a little less restrictive, it could be comparable, or it could be more restrictive.
It's almost like a case by case, I think.
Right.
Because it depends on where it is.
We had an application in front of us some time back, but there was a question of a stream that's between an already developed area, Ivanhoe, and the new developed area. And was that a stream? that fell under
It's regulated.
jurisdiction and how we were going to address.
So I would answer that by saying you'd have to look at your zoning map. And if it shows as a stream protection district, then you would regulate it as a stream. But even if it meets the definition, if it's not depicted on your zoning map, I don't know how you can call that a stream legally.
Yeah.
I think
Because
that would fit, I mean, that had a shoreline zone, that's in the shoreline.
And with that though,
And that wouldn't be covered by this gray area of just being NERPA versus.
Right.
yeah, and there's a current gray area within our performance standard, the stream, not the definition, where the description of the zone. It includes anything mapped or unmapped.
Yeah.
So mapped
Right.
is even a wild card. It may not be. And to answer that, I went out, I had told him, Mike used to be my DEP contact years ago.
Hmm.
Well, I'm going back in time now, on. So
Speak up.
if I had a question, in the gray area, Mike would be the one we'd call, and in some case, I remember one time, I think Renee was right and I was wrong in one case.
Once maybe.
Once maybe, yeah. But in any case, the mapped or unmapped piece and is important, because it's always been hammered that if it has to be mapped, it's like a zoning ordinance. And that gives everybody, when you're looking it up at home, wherever you are, this is what we have on the ground here. Now, to say something may be there, you'd essentially either do you have to map the entire town, or do you have to unmap the entire town? I don't know. But in one case, there was a stream, we depicted it as a stream, we still do. And I called Colin Clark, he's our current DEP contact. And back when Colin had time, he would come and do a field visit with me, and we walked what I thought was a stream, it was mapped, and I bet we were 50 yards out in the woods downstream before he found aquatic life in it. So it's just an unknown, and the thing is with this, you all, when you get a presentation, if something's mapped as that means somebody did an analysis, and they're gonna be held to the same setbacks under the National Resource Protection Act. The town doesn't need to regulate it further. And under that act, the act has built-in relief through these permit by rules sections. So I don't know if you ever heard of that, if certain areas you can build within 25 feet, or you can take out certain wetland areas. That's within that. In local shoreline, we don't have that. So when they overlap, you're actually putting more of a burden on a landowner or a developer. But so I'm certified in state shoreline zoning. All that means is the state said, these are the minimum standards we need. We're going to impose on the town. So we're going to train CEOs to enforce that. That's the limit of my training. Just because I may or may not know more, I couldn't tell you definitively aquatic life and aquatic plant life. So for me to regulate you or tell you can't put your house somewhere because of something I'm unsure of, leaves a hole somewhere. So that's why we're looked at just going with the state minimum requirement on this, so everybody can be on the same page. It's not like it goes away. It just becomes clearer for everybody who is in their lane, and this is my lane, this minimum state shoreline zone.
Well, let me ask you this, Tom, because I presume you were familiar with what we already have on the books.
Yep.
Big presumption, right? I know darn well you were. And you're familiar with what is being presented.
Yes.
Would you say that we have currently more protection in our ordinance than what is being presented? Or are we losing some of the protections that we have?
I would say we would gain protection. Because currently it's unenforceable.
Yeah.
Meaning the town, like many, did not take the steps to either require that in every permit, you come in for a shed or a garage or an expansion, that you present me with a hydrology report of your lot. Because you may have an unmapped stream, I have no way of telling. There's no way the town's gonna do that. Like, I'll speak for the town. Yeah, the other one is, I'm not qualified. I've never been trained in that. And I don't have a state certification in it, so I can't determine that to the point where I would impose a penalty on you, which is what enforcement is, if you violated it. Now, I would probably call DEP in and let them take the reins, if they would, if they may say at some point, well, this is in your ordinance, you deal with it. I've had that happen in other cases. So by going this route, we're getting something that is actually enforceable. So by that, it's, I'd say it's more restrictive. It sounds less restrictive, I get it, but it currently isn't working right now. And it hasn't been for some time. It just hasn't been since this initiation.
And the other thing, Larry, as we've seen, we have these different groups, whether it's the sightlines or whatever, that bring in both their expertise and then other experts, right? So if I have a question, I might call Tom, but I also will probably call Flycatcher, who does wetland delineations and all that stuff, and give me specifically what I can, have, or I can have that person talk to my clients to say, here's what I think you can do with this particular lot or parcel of land. Right? Just one other thing, I don't want to go too far, this is probably too far in the weeds, but. And actually, I think it was somebody, it was one of those firms that mentioned it. There was, quote, a stream. I'm not gonna go into vernal pools because that's another rabbit hole. But there was a stream that, again, is it a stream, isn't a stream? And then the discussion became, it was man-made, right? And it turns out that someone had literally taken a backhoe and hauled out some dirt to create a channel for the water to drain off another section of the land. How is that treated in here, or is it even considered as a stream?
Under the proposed definition, and by the way, I'm not trying to sell you the draft language. I just drafted it because that's what I was asked to do, and it's what it would make your ordinance consistent. Whatever you do with that is up to you.
We're not pushing you to get what I just need to understand.
Sure. Under the proposed language, that would never be picked up. Under the current, I don't know. It may be if it's become naturalized for a long enough period of time so that you do find aquatic insects and it does meet the different criteria, it could be regulated. To be fair too, by the way, if I have no idea what the town of Topsham's desire is with streams or wetlands or anything of the sort. This is just shoreland zoning. If the town wishes to, say the planning board wants to be able to require additional setbacks from these smaller channels that could be deemed streams under the current definition of a stream, you could craft the ordinance language so that the shoreland zoning definition for a stream protection district, those streams that show up on the map are this, the new language, the National Hydrography Data Set. And under the subdivision ordinance or site plan review ordinance, you could develop your own separate stream definition and have whatever you want there. This is intended to just meet the state minimum requirements, but if it's important to the town within subdivisions or large scale developments to still protect these smaller channels, then that's certainly a viable option.
So 2 things. One is I think we have enough on our plate right now.
Right. Just
Number
throw it out.
2 is we don't do policy, so it would actually have to come from the select board.
Gotcha.
But I think we leave that alone for now anyway.
Yeah.
And just continue with this.
I just wanted to throw that out there. The only other thing before we leave streams, the only other comment I want to make is, is the proposed definition less or more restrictive? And I don't know. And, Tom weighed in on that without really doing a comparison. But one way, if the town wishes to leave its current stream definition as it is, the way down to actually make that work so that it is more restrictive would be to hire somebody, and I do some stream determinations, but I would not do this sort of project, most likely. But to have somebody with a GPS unit that knows a professional that knows how to identify streams and canvass the town, which is going to take a lot of time, and it's going to cost the town a fortune. to go out and find every possible channel that would meet that definition.
And we'll
And then
have
put
half
it
the
on the
town
map.
that wanna do that, half the town that won't, so.
And if
we
they
should-
did
we should
that,
Move on from that discussion.
so if you did that, then it would be, we'd be making the map and the ordinance less restrictive with the proposed change. But since that hasn't happened, it's probably a wash, or we could be making it more restrictive. So that's,
But to your point of making it more restrictive in the ordinance. Without doing that, NERPA's still, NERPA's still strict.
Right,
Always have,
So,
right.
it'd be redundant.
but really, just the summary is the shoreline ordinance needs, and the maps need to line up. They don't, right? They need to line up.
Yeah.
Because
speaking of that, do we have
Do we have a new map?
Not yet.
That was just a teaser at the bottom.
Yeah.
Okay.
I've been waiting with bated breath for that new map.
All right,
Sorry.
moving on. I don't usually use gavel during workshops, but let's keep going.
Just 10 more comments about street. No, I'm kidding. All right, so there are other changes, and I'm almost done. There are some other changes, as I mentioned earlier on, in the section entitled Administration, Enforcement, and Penalties, Article Roman numeral 9. Some changes to that section. Again, just to make it consistent with Chapter 1000. I'll leave it at that. Same thing with Article Roman numeral 10, Board of Appeals. There's also a number of changes in there to make it consistent with the state minimum standards and how the Board of Appeals will conduct itself with appeals and that process.
Hang on a second, are you guys gonna be talking to the Board of Appeals?
Sure,
I mean, just to let
I mean-
them know, right?
yeah,
Okay.
I mean, we'll let them know what's happening.
And then we touched a little bit on the map, on some of the inconsistencies. That's outside of the scope that I'm working on, except that through the process that I was tasked with by the town to develop the ordinance standards to be consistent, I had to refer to the map a number of times, and I did. There were some pretty apparent inconsistencies. Streams and wetlands both appeared to be pretty inconsistent with the town's current definitions and current ordinance, as well as the draft language we drafted up. So I understand that effort's underway, and hopefully you'll see a new map coming out at some point in the near future. And then just to reiterate what I've already mentioned, and again, I'm not trying to sell this to the town. I mean, if the town never adopts this, so be it. I'll still sleep at night. I don't live in Topsham. It's a beautiful town. But I just want to reiterate that even if the town changes its ordinance to be consistent with the draft changes that we've prepared for the town, so that the resource protection around waterfowl, wading bird habitats goes away. Some of the wetlands on the map would presumably be reduced in size because the town ordinance currently and the proposed does not regulate forested wetlands, and the map seems to currently regulate certain forested wetlands. So it's inconsistent in that sense. And if some of the streams are removed, for instance, possibly from the zoning map as a result of the new language, it's not to say that they are not protected. Again, you have the U.S. Army Corps of Engineers regulates all of those resources. You cannot impact 1 square foot of a forested wetland without a permit from the Army Corps of Engineers.
We learned that a number of years ago. We still don't have our business park over there, anyway.
Oh, okay. Sore subject. And then the DEP, obviously, under the Natural Resources Protection Act, regulates it. So they are regulated. It's shoreland zoning is generally was in its inception was intended to be kind of the broader, larger, more sensitive, more environmentally important. I hate to use that word, but more important environmentally resources. And it's not intended to regulate the minutia, so to speak, the smaller resources that are regulated by others, but some towns do. So, anyway, that's all I have. If you'd like me to keep going, I will. But
Well, don't
I'll
leave the
spare you.
podium quite yet. Were there other questions from you guys?
Yeah,
It's fast.
question I have, why, is the football game?
No, but we're over my 15-minute deadline.
Oh. So. DEP would be the one to address the National Resources Protection Act
Correct.
type stuff. That's presuming that you can get DEP to come down and do something. Is that a fair statement?
Yes,
And same with, let's say, the Army Corps of Engineers.
even harder.
But they may say, yeah, they may say, no, we don't care. And therefore, if you're taking that out of our local ordinance, we have lost that protection. Would that be fair to say?
You would lose the benefit of having somebody local go take a look at it. The question is, does your local guy, have time? Does he have the resources to go out? And does he have the knowledge or the skill set? Or, does he feel comfortable with the knowledge he has to make those determinations?
Right.
DEP
If we don't have that in our ordinance, then we don't have the power to say, okay, landowner, developer, whatever, you need to hire and provide a report to us based on, because Tom doesn't have that skill set, he doesn't have the license for it, but they need to provide that information to us by somebody who does have that skill set and license. So by removing it, and if you have DEP saying, no, we don't care, Army Corps of Engineers says, good luck, then we don't have anything to them say, we can enforce that.
Yeah, you would have zero enforcement on that if you don't have that particular channel defined or mapped on your zoning map.
In the ordinance.
So I'd like to jump in there because the planning board does have the authority to request other studies as part of both subdivision and site plan. And all site plans and subdivisions are conditioned on applicants getting all federal, state, and local approvals that are required, which covers NERPA permits, Army Corps of Engineer permits. I've never seen a developer not get those. If you were to be concerned, maybe it would be smaller homeowners that you'd want to be worried about, but if we're talking developers, we have a lot of built-in mechanisms to catch that.
It's pretty much standard practice as it is. Right? So I was gonna say the same thing, you said it better. Right. So. I'm sorry? Come on, and quicker. See, we got him over here, all right. Anything else from the board, right? Sky, did you wanna say anything?
I like to support Tom, and I guess the only thing I'd say is, there's been a lot of or accurate, kudos to Tom from Mike tonight, which is very true. We're incredibly lucky to have Tom. We will not always have Tom, and when Tom, finally gets to a well-earned retirement, we will probably have a young code enforcement officer who may not have certifications when they're hired. That is just the reality of code enforcement in Maine at this point. So I just want to be careful that we do not pin our ordinance on having a really experienced code officer, because that will not always be the case. And I would hate to have an inexperienced code officer, a planning department that, has worked with this stuff somewhat, but we don't do the bread and butter of shoreland. It's mostly smaller stuff that Tom works with. And we're having to come in and try to change the ordinance because we're realizing, oh gosh, we don't have the expertise for this anymore. We didn't hire someone who can delineate streams because that would drive wages up. So I think that that's important that we consider that we're trying to future-proof right now, as well as deal with an issue that is coming up and Tom is bringing up to us at this point.
So adopting this language is going to help be better prepared when you do retire.
When I go,
Yeah.
it'll help you while I'm here too.
Okay.
But Tom, no one's trying to give you any hint. Come on, guys.
I just wanted to put that.
But
Yeah,
that's,
sorry, Tom, it's good for you now too.
but to her point, Larry, that is one of your expressed concerns at our last meeting, right? So I guess from my perspective, I appreciate your efforts, right?
Sure.
Yep,
My
I
pleasure.
appreciate you answering a lot of, I'll say, really tough questions. But bottom line is I think this is moving in the right direction. And obviously, we need to go through a public hearing, but I wouldn't have any problem supporting this. Anybody else want to say anything? Or?
Nope, appreciate the information.
My pleasure. Thanks for the invitation.
Thank you for your time.
Yeah, Tom.
Oh, you're very welcome. Other questions come up after the meeting, you can reach me as well, so. Tom has my number, Sky has at least my email.
I'll leave it up to them whether or not they think we need you for the public hearing.
Sure.
So we're good to move on to public hearing?
Yeah.
Okay, we should.
Unless
be able to-
anybody objects.
Yeah, we should be able to have, a map by then, I really hope for tonight, but there's just. Like kind of alluded to it around the coastal wetlands and stuff, and the fact that the map is currently inaccurate, we're just trying to make sure everything is good. So we show you something that is accurate, and we do not repeat mistakes and show you something that is inaccurate, we're trying to make sure it's all good.
That would definitely be helpful.
Yes. Yeah,
All right.
I had wanted to, it just did not happen, and I am sorry about that.
So I do have the ability to adjourn, I think, on that, so. We're to adjourn. Thank you very much.
You're welcome.